All rise. The Court of Appeal in and for the Fifth District of the State of Florida is now in session. The Honorable Scott Makar, Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good morning, everyone. I want to start out by saying thank you to council for appearing here on relatively short notice. We very much appreciate it. It's an interesting case. We will now hear argument in 24-2594, Johnson versus State of Florida. Counsel, you prepared?
Yes.
Please proceed.
Good morning, Your Honor. May it please the court, my name is Jacqueline Brandt, and I represent the appellant Jeremy Johnson in this case. At issue in this appeal is whether or not the felon in possession statute, that is section 790.23, is unconstitutional under the Second Amendment to the United States Constitution as applied to Mr. Johnson.
Is that as applied challenge preserved?
Right. So the preservation issue is a little spotty. And as you rightly point out, I believe it is in the sense that Mr. Johnson opted to file a pro se motion to dismiss. He clearly challenged the statute on facial grounds, but he uses on at least two occasions in his actual amended motion that the court heard argument on, where he essentially throws in the as-applied challenge as well, the language. Some other language within the motion to dismiss that he filed sort of lends to the idea that he's also arguing an as-applied challenge, although because he was a pro se litigant, and I understand, he has the same obligation as an attorney would.
And in fact, that's discussed thoroughly with pro se defendants at the time of the Ferrettering, right?
Absolutely.
So let me unwrap a little bit what you've said. You contend, do you concede it's a facial challenge below?
As to the motion,
Yes, the amended motion.
not entirely. I think there's some give and take. If
Okay.
there is a preservation issue as to the as-applied challenge, because obviously we all know that the facial challenge to almost any statute is nearly impossible to make that sort of argument. And
Well, the best that can be said about the motion itself is that at the very end, it says, based on the grounds elaborated in the constitutional application of the statutes to the set of facts through a facial and as applied challenge.
right.
So that's the only thing in the motion that would tie it in directly.
Right, and he does reference, I may be able to give you a.
References range and other cases that are
That is
as applied challenges, is that correct?
That is correct.
And did the state's response to the motion to dismiss below that address the as applied challenge, did it not?
Absolutely. And I understand why they did that, even if there was a question as to, whether or not it was preserved. If presuming the trial court found that it was preserved, as to an as applied challenge, they didn't want to waive any, argument as to challenging an as applied challenge as to this.
And then during the hearing, what was addressed was his specific predicate convictions, is that correct?
That is correct. And it was a bit bizarre in that it was almost like the courts preserved the issue, thoughtfully so, right?
But can the court preserve an issue? I mean, the Supreme Court of Florida makes very clear in the precedent, you look to either the objection or the motion.
Right.
And to preserve it, it has to be the precise legal ground, does it not?
As we briefly discussed, he does throw in the language as applied, and he does go into briefly the status of felons as nonviolent or whatever, and cites it as applied
Sure.
challenge.
So the only place in the motion that I found the word as applies is the last paragraph.
Right,
And in that paragraph, it's actually in an introductory clause. In other words, the introductory clause, and I'm looking, I think it's record page 65, and Judge Makar astutely already read it, but based on the grounds elaborated and the constitutional application of statutes to the set of facts through facial as applied challenge, cites a statute, comma. Then he says, the facial invalidity of the statute, and he goes on.
right.
And that's the concluding paragraph, but the motion matters.
I know it
So
does.
I'm trying to emphasize, the reason I'm walking through this is because I want you to respond to what I'm looking at.
Absolutely.
And he opens the motion in the first paragraph on page 49. The grounds of the motion are that the defendant is charged under the statute, an offense of a statute that is, quote, facially invalid and constitutionally prohibited.
Right,
4 pages later, Florida statute 790.231A is, quote, facially invalid. And it goes on to state why in that sentence. Record 53 to 54, the conviction for the violation of a facially invalid statute. Record page 60, in 2023, he's pointing our attention to the Edenfield case from the First District. The First District Court of Appeals expressed that the conviction for a violation of a facially invalid statute. Later on, record 62 to 63, the aforementioned grounds, precedents, and arguments serve to facially challenge the constitutionality of section 790.231A. So I am trying to understand your very best argument. He can, listen, he cites cases, and we're going to talk about the hearing in just a minute.
Right.
He cites a plethora of cases,
mhm,
as pro se defendants' motions often are. There's a lot of legal jargon being thrown around, ex post facto, detainer,
right.
other grounds far beyond a facial challenge. So whether he cites a case, whether he uses the word as applied, how does this motion preserve it?
Again, I don't have a clear answer for you because I also had the issue with
Well,
whether or
well,
not
well,
actually.
counsel, it seems to me that you've already hit upon, it's the as applied language is used in the motion,
Mhm,
right?
right.
So, I mean, I'm just saying, I think what I'm suggesting is that the trial, if I'm the trial judge here and I see that the movement has put in at least that minimal amount, there's as applied, and the trial judge seems to, at least in part, through his order, handled it as an as applied challenge, and the state itself, it sounds like, treated it as an as applied challenge. I'm not sure why you're struggling to answer the question.
Oh, well,
Isn't that your point?
absolutely. That's my point. Thank you, Your Honor.
Well, I'm not trying to argue for you. It's just where before me. I'm just trying to figure it out.
So because I have thought about this a lot, I had the same questions as well, because,
I mean, Judge Stout has made a very valid point. This
Yes.
seems to be a facial to me. It seems to be mucked up by how it was handled in some way
right,
in the briefing and so forth. If
But
it's a
I will-
facial challenge, we wouldn't be here today.
right,
It'd
absolutely.
that's an easy
And that's,
decision.
right, exactly. And that's also that was my thought process as well. If it was a facial challenge, I really wouldn't be here today, at least if it was clear cut, a
Yeah.
facial challenge as it stands.
And if I could, do you want time for rebuttal? I forgot to
I
ask. I'm
apologize.
sorry.
Yes.
No, how much would you like?
5.
5 minutes. Okay, sorry for that.
Thank you.
All right.
I apologize.
No,
No, for purposes of, I think the reason that the court was interested in treating it, even if it was sort of arguable about whether or not it was an as-applied challenge, was because of the sort of felon that Mr. Johnson was convicted of, or sort of.
Well, let me ask you
What sort-
that. I'm sorry. No, go ahead. No, go ahead. Okay. The kind of person or conviction and so forth. I'm really confused by this record because there seemed to be a quote stipulation or agreement that he was nonviolent. I couldn't quite see where that came from, but it is what it is.
Right,
But is he non-habitual as well? I mean, the language I see from the cases law say you have to be nonviolent, non-habitual offender. Just because he's not violent doesn't mean that he has to also be non-habitual. Is
right,
that?
absolutely. That is correct. But I think,
Because I mean, I'm sorry, Brooke, keep your thought. The arrest here was in response to a call that shots were fired. Right?
he denied that.
Right, I got it. He wasn't
Fair enough.
charged.
Mhm.
But I mean, the circumstances were that shots fired, officers show up. So you have a weapon? Oh, no, I have a weapon. Well, it turned out he lied. He had a weapon. So we have an offender here who had a weapon, lied about it to law enforcement officers and was a felon, nonviolent. I'm not sure about habitual. Doesn't seem to me like that's the best candidate for restoring the right here to keep and bear arms.
Right, and I don't necessarily disagree with you. There has been, various cases where there would be, potentially one prior felony conviction, for example, that was nonviolent, which would then serve as a good, for example, a case to certify conflict, or to certify to the Florida Supreme Court as to what the Florida Supreme Court thinks on this particular issue, whether or not there needs to be some sort of dangerousness determination or not.
Right, well, what is the test at this point? What should we be looking at? What was the trial judge looking at below?
As to the dangerousness or as to the test?
As to the test, what is the test?
It is the test that was put forth in Bruin. And it is essentially that if the plain text of the Second Amendment covers the conduct, and some of the language, I'll stop myself. I'll finish the test. I'll explain the test, and then I'll explain. If the text of the Second Amendment covers the conduct, then the state has a burden of proving that there's a historical tradition that supports that sort of regulation.
So as to step one below, it seems like the state argued one thing below and is arguing something different on appeal. They argued step one below and step two on appeal. So with respect to step one, where are we?
Right. So the biggest issue with step one has been the question of who constitutes the people protected under the Second Amendment. And there's been sort of a lot of dicta and case law that touches on that, nothing directly on point. However, I thought it was very clear from the reading of Heller, in Scalia's opinion, that it is the Second Amendment is a pre-existing right. It's a fundamental right. The only way that I could equate it in my mind was sort of thinking of it as, if I've been previously convicted of a felony, does that mean that I cannot then later on, invoke my right to remain silent, for example? Right. So
there was dicta from Helen and Bruin. I think that that's pretty clear at this point, that
Right.
That it was dicta, that it was presumptively lawful,
mhm.
and so now we're moving forward. We have a case that's not necessarily binding, but saying that felons who essentially they're not currently under sentence, but they are part of the people. And that is now also, the law has evolved significantly since this case was decided. It's evolving every day, but I think, let's assume that Mr. Johnson is part of the people. So we need to move to the second step. You said, this isn't an ideal case. Well, we don't get to choose the cases that come to us,
Of course.
but there are, there's a lot of question when it comes to drug convictions and things like that. What are we looking at there? You mentioned dangerousness. How is this going to be assessed? There are several buckets of how the different courts are assessing it. How should we assess it?
Well, I'm under the supremacy clause, as well as just U.S. Supreme Court case law. Their decisions are binding on, obviously our federal interpretation of the constitutionality of statutes. And Rami actually touches on this, but doesn't hit the point exactly. So
Are we
yeah,
talking about Rahimi?
Right,
I just want to make sure.
yeah,
There's new
absolutely.
cases all the time. I may have missed something.
I wasn't entirely sure of the pronunciation. So, the idea is that we, the convicted felon thing is one thing, but if someone is convicted of a violent offense or has shown that they are dangerous to society, those are theoretically the people we would want to not be able to bear firearms, right? And so the only test as to like, where we are right now with Mr. Johnson is that there's no indication that, as Judge Maycard pointed out, I believe, there was a stipulation amongst the parties that said, none of his prior felony offenses were violent. Now, how they make that determination, I don't know. That would be up to the U.S. Supreme Court. They did the case in Rahimi. Actually, they made a separate dangerousness finding, and then of course, he had his own other things going on as well.
And Rahimi's a little different. That was a temporary disarmament. Is that correct?
Right, that's correct.
All right. So essentially now again, we have three buckets where the case law is developed. It seems like we have, felons as a group, which is sort of the state's argument, I think, on appeal versus below, because now we're in step 2. And that, or is it a felony by felony assessment? Or are we looking at an individualized dangerousness finding? Where would you ask this court to go?
I believe that there should be at least some sort of individual. I do understand that there is case law that says that we don't have, there is no requirement that the courts go through a case by case basis and make these dangerousness determinations. However, it just doesn't feel right, sort of, for lack of a better way to explain it, to punish someone who, was convicted of a drug offense versus, someone who was convicted of a violent, offense.
Can you point to the record, exactly what the criminal record is in this case? What was? I mean, because the reason I ask that is it's confusing to me because the trial judge said, Mr. Johnson, correct, is Mr. Johnson correct that his prior felony is just possession of a controlled substance? And the response was basically, yes, just the possession of cocaine. He may also have a prior possession of controlled substance on his record, blah, blah. He has multiple felonies. I can't find in the record what his multiple felonies are. All I know is there's this possession of cocaine everyone agrees upon, but what else does he have in his background?
So from it's listed in the score sheet, and that didn't give me a lot of info as well, but there were a couple of different felony convictions for drug possession.
Sale. There's also a sale.
There is a sale, although there was absolutely no information as to that particular charge. And I don't know if we're talking about, the current version of the statute, because I'm sure, as Your Honor.
The record indicates sale.
It does, on the score sheet, it does, yes. But there is.
If I recall correctly, it represents 5 felons.
You're correct.
In the transcript Judge Makar just read from at the very beginning, Judge Branham's question to the state, is Mr. Johnson correct, is based on Mr. Johnson's representation to the trial judge before that about my conviction is for possession. The judge asks, and he says possession of cocaine.
Right.
Makes no mention of sale. Makes no mention of 4 other felonies beside the possession he references. Just references the possession. And the state initially confirms, but later in the transcript corrects itself. Do they not?
They said they did not know for sure, because it sounded like it may have been like a negotiated plea. And so he entered, it might have been a charge that was amended. I don't know.
The possession was the predicate felony.
Right. That's
for
correct.
The firearm.
Right. There were other.
That's what they opted for, because that was the most recent. That's what's in there, is that was the 2022
The
charge.
charge.
Right, right. And there were a couple.
Conviction.
There were a couple of different charges from the 2022 case that are listed as the lessers. And they were all, I think, at least as the 2022 case, they were just possession charges. The sale, I don't know. With that,
Okay, you can,
unless.
you have more, we can add more time, so.
Yeah, I'd like to ask
Sure.
further questions.
Sure.
So, all right, I agree. The record shows several possessions and, a prior sale. So what would you have us do with those at this point?
I think there should be some sort of, at least a review of certain sort of felony convictions, because they're not all created equal,
Well,
right?
the burden is on the state, is it not, to come forward with an analog? Have they done that in this case?
To some extent, but historically speaking, I think that, most of any laws that had disarmed people along our country's history had to do with, politically motivated, maybe not necessarily, but many of them were politically motivated, racially motivated, whatever. And so I think to take one's ability to bear a firearm away forever as a result of a felony conviction would require some sort of review, or at least maybe even an enumerated statute that, lists what are the violent felony offenses, like as to, whether or not they should
More
be.
questions? Okay, well, we've gone well past your time and
Okay.
I'm be very lenient. So what we're going to do is give you 2 minutes for rebuttal.
Thank you.
All right, and we'll add 2 minutes to the state side if you need it. You can use it if you need to.
Good morning, Your Honors. May it please the court. Christine Pratt for the state. The state agrees with you, Judge Nakar. The record is confusing, and it's confusing
Thank you.
because in this case, Mr. Johnson failed to preserve his as-applied challenge. He never brought it below, and that's exactly why we have the problem we do today.
Well, I mean, he put it in his motion. He did say as applied. He's a pro se prisoner, so and then the trial judge picked up on it. And then in his order said alternatively, I do an as applied. So why isn't that enough?
It's not enough because just throwing out magic words to say as applied doesn't do the necessary action of explaining to the court, letting the court fully flesh out the record and saying, here is why the statute is unconstitutional as applied to me. Here's why in my case, it's unconstitutional because of the nature of my convictions, because the score sheet is wrong. I object. The defendant never objected either at the motion to dismiss hearing or never objected to the score sheet. And even on appeal, the defendant never disputes this sale of cocaine conviction.
So, I'm sorry, go ahead.
But maybe that's because it was accurate, or he chose not to object. That doesn't make something unpreserved. And what of the state responding to it in a written response below? No objection from the state when the judge is going on and on about his specific convictions. No appeal of the nonviolent finding by the judge from the state. And no issue when the judge says, even if it's as applied, I'm bound by Edenfield. So how is that not preserved? It was presented to the judge inquired about it, the judge ruled on it. That sounds like preservation. It doesn't have to be perfect, but that sounds like preservation to me. How do you say now, none of that, because it wasn't perfect and he didn't object, even though I don't represent him, that is not preserved?
So it's very clear in the trial court's order that this was a facial challenge. It's very clear when you read the motion to dismiss, this is a facial challenge. And it is the state's position that the court can't preserve an issue. The court is not the litigant, and it is not the court that performs the job of preservation. It is the litigant's job. And in this case, the litigant exercised his constitutional right to represent himself.
It may not be the court's job, but it doesn't mean that it can't happen. If the court addressed it, the state never said, hey, this isn't an as-applied challenge. I object to going into this. We can't do this. But they didn't, because they responded and to the as-applied language. And then they didn't have any issue with it.
Well, Your Honor, as a litigant who stands before the court, a litigant is going to, the state is going to answer questions when asked, but it is nevertheless the state's position that the work that was necessary to be done to preserve this, it is not preserved. It is a foundational principle in appellate court, in appellate review, that you must preserve this issue. And it's very clear that this is a murky record. The state never amended the information because the defendant in this case never raised an as-applied challenge. So this
Wait,
is
I'm
Why
sorry.
would they need to amend the information?
just to say that the state in this case was clearly responding on the fly to the court's questions. This was not fully fleshed out, fully litigated. And when a judge asks the question, the state is going to answer it. But that does not mean in this case that it's the state's position that it is not preserved.
So I'm sorry.
No, go ahead. Go ahead.
May I
Sorry.
back up just a minute? I think the view of the forest might help the discussion on individual trees. So a pro se defendant comes in from the Duval County Jail. It happens every day and every week in the 8 felony courtrooms surrounding the atrium right outside. He comes in, he is elected against all wisdom and against the conversation had by the trial judge to represent himself. The judge is clear throughout every Feretta inquiry that you do so at your peril, but you're held to the same standards as lawyers are. He comes in, Judge Branham says, what would you like to file today? That's when he's presented the amended motion to dismiss. Let's get that filed. And it seems to me from reading the record, that's the first time the judge saw that amended motion to dismiss. He doesn't say that, but it seems clear from the record the first time the judge sees it. The judge starts looking at it. He's referencing the cases McDonald, Heller, things that are routine in constitutional challenges to the PFCF statute. And then ultimately he begins to ask questions. I'll come to the state's written response a little bit later during the course of the argument. But he asked the defendant point blank, do you wish to address any other arguments not presented in your written motion? And the defendant unequivocally says, no, sir. So we're locked to that written motion. Now, the judge asks questions admittedly and almost assuming it's an as-applied challenge. The state responds to the questions like you referenced. I have no idea why the state of Florida files a written response on an as-applied challenge, but the state cannot preserve an issue. And I'm curious if the trial judge, who's a smart judge, just flat missed it. In paragraph 3 of his order, bottom of record page 80, paragraph 3, the facial nature of the challenge resolves defendant's claim against him. So the judge, after he actually took the matter under advisement at the end of the hearing, went back to his chambers and had a little bit more time than a crowded courtroom and a trial schedule can permit in a felony courtroom, actually reads the defendant's motion and then concludes in a written order, the facial nature of the challenge resolves it against him. It's after that in paragraph 4, he says, even if the court treated defendant's motion as an as-applied challenge, which is a clear implication, is it not, that it's a facial challenge. If you have to treat something as applied, the inherent implication is it is not that in which it's treated. So I've never left the preservation. I agree with Judge Makar, reasonable minds can differ. These two wonderful judges beside me are brilliant and excellent, and it's my privilege to work with them. I have never left that question because that's a threshold question for us, jurisdiction, preservation. And I don't understand how we have preservation even with the state's wavered written response. Help me. What's the weakness in that position?
Your Honor, I don't think there's a weakness in that position. I think it's very, very clear for all the reasons that you laid out, the motion to dismiss.
Well, let me throw out, if we were in the civil context, there's this idea of conforming the case to the evidence and how it progresses. In other words, you have the pleading and then they tee it up for a hearing and then things evolve and they go in somewhat different direction a little bit. And then the trial judge is allowed, at least in the civil context, to conform the case to what was presented. And that seems to be what happened here, arguably, which is the pro se litigant did say it's unconstitutional as applied. It's in the motion. That wasn't the most of it, but it was there. And the trial judge picked up on that. And we had, if it was just facial, the hearing would have lasted 2 minutes. Okay. Right. But there seemed to be this fleshing out of the case law and Rahimi and this and that, and stipulation, the factual stipulation and so forth, which wasn't necessary for a facial challenge. So you could look at it and say it's evolved into not the judge preserving it, but basically litigating or adjudicating what was presented to him. This, as it was mentioned, the state didn't object. Your Honor, you can't go there. You can't. There's no motion in my recollection of saying motion for rehearing. You need to strike that part of your memo, your order. There's no as applied here. So, and then the state sort of, I guess, as I understand it, played along with the as applied. So why isn't that enough? I mean, that's something.
Yes, but it's still not enough because it's necessary for an appellate court to have a strong record, that the appellate court really understands what facts we're working on, that we're working under. And in this case, the record is very muddy.
Should we remand it back for a new hearing?
No, Your Honor, it's not necessary to remand because it is clear on an issue of preservation.
But okay. But if we thought it was preserved, then the record's not really good. Could we remand it, or is that beyond our authority?
So it is, my first answer to that question is that the state still prevails, even if the court wants the state to proceed under the assumption that the as-applied challenge is preserved. And so there's no need to remand in this case whatsoever. And the reason for that, the reason why the state still prevails is because Mr. Johnson is a dangerous felon. He has a conviction for sale of cocaine, which is a dangerous felony. And he's also a repeat offender.
But I thought there was a stipulation that he's nonviolent, but you're saying he's dangerous.
Well, Your Honor, that's a legal judgment as to whether his convictions constitute a dangerous felony is a legal judgment. That is reviewed de novo with this court.
It's a legal finding that you did not appeal.
It is an issue of law whether a conviction is dangerous.
You're mixing terms. He said he's nonviolent. That was in the order. You did not appeal that. We can talk about whether or not a sale is a quote unquote dangerous conviction. And I have plenty of questions about that I would love to ask. But first things first, you did not appeal that. So how do we have de novo review of it? That's not, talk about preservation. You didn't appeal. If you have an issue with the finding in the judge's order about him being nonviolent or he doesn't have any violent convictions, the state didn't take any issue with that.
The state argues in its answer brief that Mr. Johnson is a dangerous felon. So that's contesting the trial judges. If the state's brief wasn't clear, just please allow me to.
But the stipulation below is that he's nonviolent. So what, you can't argue.
Stipulation, Your Honor.
Let's.
No stipulation, Your Honor.
Or the agreement or whatever you want to
So,
call it. Yeah.
The state would not, here's on page 153 of the record, the state would also contend, while possession of cocaine is not on its face a violent offense. That's not the same as saying the man at issue in this case is a violent felon because, as the state clarified later, he was convicted in 2008 of the sale and delivery of cocaine. So what the state said at the motion to dismiss hearing is that possession of cocaine is not on its face a violent offense.
Where was this in the record
So
about
this
it?
is on page 153,
Okay, I'm looking at it.
line 23.
The state would also
motion to
contend that while
dismiss
possession of cocaine is not on its face a violent offense, the state does have an interest in given that there is harsher punishment, Florida above. The state would.
It came up in the fact that the state was talking about how there's armed trafficking. And the judge was questioning, well, was he convicted of armed trafficking? And then there was a back and forth about that. And that's where it came up, not so much that the possession on its face is not violent. So there was, and it's odd, I agree, but that's why I would think if you disputed that statement, wouldn't you appeal that from the order? Wouldn't you have an issue with what the judge said? If you're saying, no, he's dangerous, he's violent, he's all these things, but the judge said that there was a stipulation that he wasn't, why would you not contest that? Why would you not cross appeal that issue?
Well, so, Your Honor, granted, if the briefs are not clear, if decision makers didn't cross appeal, I can't answer to that, but I can state very clearly today, it is the state's position that Mr. Johnson is a violent felon, and it is the state's position that the state never conceded or stipulated, whatever the trial court's order may.
I don't see how you can do that, though. I mean, it's been adjudicated. We're not going to re-adjudicate that factual issue.
But it's not a factual issue. It is a legal determination whether his convictions constitute a violent felony, whether he is a violent felon. That is a legal determination. Whether it's not a factual, it's not based on the facts. And I can.
Well, I think what you're saying is that in doing the analog and all that sort of analysis on the second prong, that you may concede he's nonviolent, but he doesn't meet the legal test for that second prong.
That's correct, Your Honor.
Is that what you're trying to say?
That's right. So under Bruin Step 2, in looking to determine whether his convictions are punishable or considered violent felonies, there's two court decisions that the state would love to bring to the attention of the court. So, and they're both cited. One for sure is cited in our answer brief, and the other I'll cite for you here. The first is United States versus Williams by the Sixth Circuit in 2024. The citation is 113 F 4th 637. It says that the courts consider a defendant's entire criminal record, not just the specific felony. So the court, in determining whether a felon is a violent felon, looks to his entire record. And in the Fifth Circuit, in United States versus Hernandez, decided in 2025, the citation is 159 F 4th 425. The court there said the relevant consideration is a defendant's prior convictions that are punishable by imprisonment for a term exceeding 1 year, not unproven conduct. So this is what the court on appeal, the appellate court decides the legal question: is the defendant's convictions violent or not violent? That is a legal determination that's de novo before the court.
The fact is the existence of the conviction.
That's correct, Your Honor. Yes.
The category, or not category, because I don't want to be confusing. Whether or not it clears a legal threshold, that is entirely a court's call. That's legal. You agree?
Yes, Your Honor, that's exactly right. So we have, the record reflects the fact of his sale of cocaine conviction. It reflects other felonies as well, such as possession of MDMA, possession of cocaine, other misdemeanors. We have the score sheet. Those facts are established by the trial court. But the determination about what to do with those convictions, do those convictions constitute violent felonies, is a purely legal determination that courts have made, numerous courts have made, regarding the sale of a drug conviction. The sale of a drug conviction is a violent felony.
Right, so where are you getting that from? So let me back up 1 second. So that's not the argument that the state initially made on appeal. It was a class felons, that we can disarm everybody. Is that not your argument today?
So, Your Honor, that is what the state's brief stated. That particular statement goes well beyond the facts of this case. That is not the case before the court today. So it is the state's position that it's unnecessary to even reach that issue. That's not the case before us about whether you can disarm all felons. Mr. Johnson is a dangerous felon. He's a violent felon. And that is the issue before this court today. So the brief just simply went further than it was necessary to go.
Well,
And I'm happy to.
Again, I'm still worried, but I mean, he may be dangerous because he bought drugs. Okay, fine. But the violent, I mean, that's a factual determination. This case has been adjudicated. He's not violent.
So that is a legal determination, Your Honor.
No, that's a fact here that the state agreed that he's nonviolent.
If you look at the record,
Okay.
the state agreed that a possession of cocaine conviction on its face is not a violent conviction. But we have additional convictions that it's necessary for this court to adjudicate whether those constitute violent felonies.
if I could, I think there's a little bit of an overlap between dangerousness and violent. And I think maybe that's where the rub is here. Because I'm assuming you're gonna go down a Kimball Mansilla road where we're gonna talk about the inherent nature of violence and the drug trade and all. That's what I'm assuming.
Yes.
But that is different than violence. Because I feel like, to me, my understanding, violence is either the enumerated felonies, right? That we know that those three categories now, which this does not fall into. I think, would we agree? It's not murder, assault, burglary, theft. Like, those are kind of the ones that courts have said, carte blanche, no. This is, and we can talk about it, but drug felonies are a bit different. We've just got a case from last week from the Fifth Circuit that said possession of methamphetamine, you are fine. They granted the as applied challenge. So,
But Your Honor, if you canvass the courts that have looked at whether drug trafficking is a violent felony, the overwhelming determination is that drug sale, drug trafficking is clearly a violent felony.
I agree, drug trafficking. This is not drug trafficking. It is a different crime. Do we have drug trafficking in Florida?
Yes, Your Honor.
Is this a drug trafficking conviction?
Drug sale is.
Correct.
Is
Not the
a
same.
violent felony. It is sufficiently similar to constitute a violent and dangerous felony.
Okay, so back it up. Where do you get your predicate to say that it is a violent felony? Where are you pulling that from?
So, Your Honor, there are numerous courts that have made this legal determination. So United States v. Williams, the Sixth Circuit case from 2024, recognized that drug dealing, drug sale poses a significant threat of danger. That if you look at the.
But in an as applied, I mean, yeah, probably there's some folks that are violent, dangerous, so forth, that have bought drugs. There's probably, some folks that are just, they bought drugs to get high and they're pacifists and they're just, they're not violent, they're not dangerous. So, I mean, to throw them all in the same bucket seems to go against an as applied challenge.
Your Honor, it is, the bucket here is the sale of drugs, not to distinguish from what you just described with somebody who maybe is just a good lucky guy, go along to get along guy who has been caught with possession. This is a conviction for sale. And so courts have recognized, including the Supreme Court, that guns are part of the tools of the trade. I don't think that's a shocking statement that.
Are we talking about Smith?
We are talking about United States v. Gambrell. That's a Seventh Circuit case from 1999.
I thought we were talking about the Supreme Court.
Yeah, it says, well, and the Supreme Court is Harmelin v. Michigan. There's a Justice Kennedy concurrence from 1991 agreeing that the sale of drugs, a drug sale conviction creates the possibility of violent confrontations. And a great analogy to that is from Taylor versus United States, a U.S. Supreme Court opinion discussing burglary. So with burglary, a person can burglarize when they're breaking into an unoccupied building, but that crime of burglary creates the risk of a violent confrontation in the same way that the sale of an illicit substance like cocaine creates the risk of a violent confrontation. They carry guns. That is not a remarkable statement to make. It is well known that they're actively going out. This is not a passive purchase, but they're actively going out, marketing these illicit substances out, and that they're creating a very high risk of a violent confrontation. We know that this happens with sale of trafficking, and that's why so many courts have found that that sale of drugs conviction is a violent felony.
And I don't disagree that what we all know sitting in this courtroom is, but I don't deny that. I'm not trying to minimize that in any way. I'm having an intellectual issue with, they talk about intrinsic violence. I don't disagree necessarily with that concept, but I do have an issue with I'm assuming we're going on a felony by felony basis at this point. Because as I said, I think there are 3 buckets. I don't know which bucket anyone is in, but I think that's the bucket we're currently in. And if that's the bucket we're in, we're only, as you stated, we're not looking at unproven conduct. I don't think we're looking at misdemeanors. We're not, we're looking at felony convictions. I'm good with that. Okay. So we have a conviction for a sale. But we also, but then we're gonna say that you could be armed and you could traffic. And so, but you haven't been, you were not charged with that. You were not convicted with that for that. But somehow that analog is going to transpose on top of the sale for which you were convicted, but is different. Where do we get this? Because if we're looking at founding era analogs, the disjoint seems to come pretty quickly, and we jump to the 1980s. And we're talking about drugs and guns and again, I don't disagree with any of
Well,
those
Let me
things.
take you back. Let me take you
Yeah,
back.
take
way
it. Take
before
me
the
back.
1980s.
Help me.
So, okay. So, Your Honor, I'd love to take you back there. Here's where, when the court looks at Bruin Step 2, and the court is deciding how is the sale of a cocaine conviction a violent felony, which the state emphatically says it is. There are two buckets of founding era analogs. The first is that the nation's history of firearms regulation shows that legislatures disarmed those who were dangerous because they posed a risk of violence. And it's exactly the reasons I explained, analogizing to burglary, that a person convicted of sale of cocaine poses a risk of violence in the same way. Here are some of the, and you can also reference this court's concurrence in Simpson that also lists this. It's all right there in the court's opinion. But in England, officers of the crown disarmed people who were, quote, dangerous to the peace of the kingdom. That's the Militia Act of 1662. The English common law punished people who went armed to terrify the king's subjects with imprisonment and forfeiture of their armor. There were disarmaments of.
But those were
people-
wartime, correct?
Well, Your Honor, it's still very relevant. It is still relevant because when you have a person who poses a risk of violence, it demonstrates that the legislature could disarm those people. And there are many more. I can keep going. That when there was a threat of armed revolt. So in cases in England with Catholics, there was a lot of fighting between these two groups. You would see that the state would disarm not just Catholics, but also non-Anglican Protestants when the pendulum swung and new people were in power. Quakers were disarmed. Virginia disarmed all of those refusing to take an oath of allegiance. Either
Are those
to-
people part of the people? Would they be part of the people if they're on the other side, if they haven't
Yes.
taken that oath?
So, Your Honor, in the Constitution, so going right to that, 1791, when the Second Amendment was ratified, the Constitution, when it speaks of the people, includes everyone, mentally ill, the intoxicated, the felons.
But they're
Um,
citizens.
That's right, Your Honor.
Right.
And so, but then of course, you look at the additional step of who you can disarm.
Mhm.
And that it was understood at the time that you could disarm people who posed a risk of violence. And that's why when someone refused to swear an oath of loyalty to the state of Virginia or to the Crown of England, there is a chance of armed revolt there. And you have a very similar sort of risk of violence when you have someone dealing in illicit substances. It's banned by the government. They carry guns. They actively go out and further their wares. That poses a risk of violence. But the other bucket, Your Honor, is on page 12 of the answer brief, we talk about smuggling tobacco was a capital offense in Virginia.
Only if it was armed, right?
Your Honor, my understanding is that the smuggling of tobacco, but I can look at that. But the bottom line is that there are several founding era laws that combated marketplaces that trafficked in illicit goods. So there were death penalty, the imposition of the death penalty for the knowing receipt of a stolen horse in Virginia in 1748. The Second Congress punished the theft of mail with death in 1792. The state and federal legislature punished counterfeiting and forgery of public securities with death. And there's numerous 1790, 1785, 1777.
The Fifth Circuit has repeatedly said that those three categories that you just named are no longer applicable analogs.
Well,
So,
the state disagrees with that, Your Honor. I do think that it's very compelling to show that you have a marketplace that's marketing in illicit goods, and the state has an opportunity to disarm people who want to engage in that marketplace, just like at the founding, there was the death penalty and there was mainly the death penalty as I look at it here. So And also in our brief, page 19 to 20, there's the death penalty for repeated thefts. So you do see at the founding, very early in our country, that we disarmed, or worse, those people who posed a risk of violence refused to show that they could be safe with their firearms, Your Honor.
If I could ask one concluding question, the United States Supreme Court is going to be hearing a case called Hemeni. Why should we just wait a few months and see how that comes out?
Well, Your Honor, you shouldn't wait because this is a very simple case.
Okay, well,
Simple.
let's assume there's as applied as was preserved and we go into the historical analog and all that. Why wouldn't the decision Hemeni at least have some bearing on the resolution of this case?
Your Honor, the state's position is that nevertheless, it's an easy case for you to decide today because Mr. Johnson is a dangerous felon. The record shows he has a sale of cocaine. He's a repeat offender. It's very easy to deal with this case under the facts as they are before.
All right. Well, thank you very much.
Thank you, Your Honor.
All right. Well, we've gone well over. You have 2 additional minutes, but we gave additional 5 or 6 minutes to the state.
Correct.
So what I'm going to do is give you a total of 5 minutes. You don't have to use it, but if you'd like to use it, you may. I'd like to ask the first question, which I just asked the other side. Why shouldn't we wait to hear from Hemeni?
I think that might be a good approach, actually, just considering the fact that the US Supreme Court is the final, the court of last resort for, in looking at how to interpret the Constitution as applied to, state statutes. So I don't disagree with that potential approach.
Even though Hemeni is about 922 and using drugs while being in possession of a firearm. And the Supreme Court decides issues, questions, not cases. So I'm honestly not 100% sure what the questions presented are in that case, but you believe that that would be helpful for us.
Well, and I apologize, I'm not entirely sure what.
Well, the issue in the case is whether the statute 922G3, which provides that it's unlawful, that an unlawful user of or addiction to any controlled substance is a basis for taking away the Second Amendment right.
Okay. I think it would give some guidance in the very least, because if we were talking about, I disagree that possession, drug possession charges or convictions. I understand there was also a sale that somehow
We don't know the details of the sale, do we? All we have is a score sheet that says there was a sale. And I think that's all we have, right?
Right. And so I don't necessarily.
Do you agree that if a statute makes it possession of here cocaine, could be some other drug, a felony, that is as ipso facto, anyone in that category, even if they're pacifist, even if they're nonviolent, even if they're just recreational user who sold some to a friend, that then have no history, no violent history. I mean, I assume you don't agree with the state's position on that.
I do not, no.
But would that person be entitled to a hearing on an as-applied challenge? Or could the statute just be used to say, sorry, you fall within this category, end of the discussion?
Well, obviously, it would depend on how that was presented to the trial court, as we see, dealing with this record. But I believe I don't know the best way to rectify the issue, but I don't think that possession of cocaine or necessarily entails, like you said, Judge Maker, that there was firearms involved and there was violence necessarily involved. I understand cocaine is a different, very dangerous drug. However, we're not dealing with a situation in which maybe he was possessing cocaine and had a firearm, for example. So I think the Supreme Court may provide at least some, I don't know.
Okay, you're saying we may ought to wait.
Yeah.
Is there anything else?
Unless there are any other questions?
I have one off the wall question.
Mhm.
He had to give a DNA sample.
Mhm.
What was that about? And if you don't know, that's fine.
I don't know
It jumped
that.
out to me when I was looking at, he was arrested for, there's a gunfire, he hid the gun, he lied about it. There's these other felonies. I'm trying to get a sense of, from a legal perspective,
Right.
what we are supposed to look at in these cases in terms of determining dangerousness or
Right.
violence.
So no, actually, now that you say that, and this is my guess, because again, the record is a little messy. There was the client wanted a motion to suppress filed based upon like an illegal search and seizure of his backpack. It may have been a swab of the firearm that they found inside of his backpack.
Okay, I got it. To see whether
So
he actually
link
had,
it.
what is his backpack? Okay.
Yeah. Unless there are any other questions, I would ask the court to reverse.
All right, I want to again thank counsel for both sides for on short notice coming in here and spending part of the morning with us and helping us out. So we will be in recess.
All rise.